Good afternoon, everyone. I would like to call to order the Legislative Commission on Data Practices. This meeting will begin, and we do have a quorum present. At this time, I think because we have a new configuration of the commission, it would be great to go around and do brief introductions. I will start. I am Senator Bonnie Westland. I represent Senate District 42, which includes Plymouth, Medicine Lake, and Maple Grove, and I am in my first term, and I will be so happy to pass the gavel today.
Representative Peggy Scott. I represent 31B, which is part of Andover, part of Oak Grove, part of Ham Lake, all of East Bethel, and 2 townships, one in Isanti County called Athens Township and one in Anoka County called Linwood Township.
I am Representative Sandra Feist. I'm in my 3rd term. I represent District 39B. It's parts of New Brighton, Columbia Heights, and St. Anthony, and happy to be here.
And I'm State Representative Steve Elkins, 50B, which is the basically the western half of Bloomington, and I am in my 4th term and my first term on this commission.
Great, thank you. How about Senator Limmer next?
Thank you, Madam Chair. I'm Warren Limmer. I represent Northwest Hennepin County, namely the communities of Maple Grove, Greenfield, Corcoran, Independence, Medina, Loretto, and Maple Plain. And I've been on this commission since its inception.
Thank you. Senator Lucero.
Good afternoon, Eric Lucero. And I've been on this commission both in the House and now in the Senate. The area that I represent, have the privilege of serving, is Albertville, St. Michael, Otsego, Elk River area. And I am very happy to be back and look forward to the continued conversation.
Thank you so much. And I know Senator May Quaid indicated she had a conflict today and will not be able to join us. Seems to be a lot of other meetings today, apparently. And I understand that Representative Hudson will be joining us, I think, today as well at some point. So the next item on our agenda is approval of the January 22nd, 2024 minutes, and I would request a motion to approve the minutes. All right, thank you so much. All those in favor of approving the minutes, say aye. Aye.
Aye.
Aye.
Opposed? Great. So our first order of business, which again makes me so happy, will be the election of the chair and vice chair. The chair of the commission will transition to the House this year for the 2025-2026 biennium. The LCC has been informed by House leadership that under the power sharing agreement in the House, the Legislative Commission on Data Practices will have a co-chair structure with one co-chair from each caucus. And are there nominations for the House co-chairs?
Madam Chair.
Senator Limmer.
I would move that Peggy be, I have a mind blank on last name.
Representative Peggy Scott as one of our co-chairs.
Representative Scott, sorry, Representative Scott. I would move her nomination.
Thank you. So one name and nomination for co-chair is our Representative Peggy Scott.
Madam Chair, I would nominate Representative Sandra Feist to be the other co-chair.
Very good. Any other nominations? I'm not going to say it 3 times. All right. We have nominated Representative Peggy Scott and Representative Sandra Feist to serve as our co-chairs for the Data Practices Commission. I will do this on a voice vote unless people really, really want this on the a roll call vote. All those in favor say aye.
Aye.
Aye. Opposed? Very good. And at this time, then I will be turning over the gavel to Representative Peggy Scott, who will be conducting the remainder of our meeting today. Thank you so much.
Thank you, Senator Westland. And I look forward to working with Representative Feist, co-chair Feist, on this commission. She and I have had some back and forth emails and conversations about where to go from here. And I think we've come up with a good sort of agenda for the next, for for sure a few meetings. So with that, we also talked about this first meeting. And with that, I'd like to invite, I think it's the next thing on the agenda, right? Oh, wait. Okay. Yeah, I guess we need to talk about, do we want a vice chair? And if so, where do we go from here? If we want to nominate folks or?
I have a process question. Can someone be nominated and appointed vice chair if they aren't here to say that they accept it? I assume that Senator May Quaid would be fine with it, but I'm not sure how that works.
I think, yes, somebody can be nominated and elected if they aren't here. I think it happened 2 years ago at the first meeting.
Senator Westland.
Thank you. I have been in touch with Senator May Quaid, who again, unfortunately was not able to be here today, and she did express an interest in serving as vice chair, so I would put her name in nomination.
Okay, and I would nominate Senator Lucero. So I guess, how do we, yes, or Senator Westland?
And we can ask if we can do this, but I have a sense we could probably do whatever we want to do. But since we have co-chairs, maybe it makes sense to have co-vice chairs if that's acceptable. And I would propose that as a resolution to this rather than having a contested vote.
Any members of the commission have any thing to add to that? I think it's a grand idea. Because Representative Feist and I have already decided that we're going to delegate a lot to the vice chairs. So anyway, all those in favor of Senator May Quaid and Senator Eric Lucero being co-vice chairs, please signify by saying aye.
Aye.
Opposed, same sign. Motion prevails. So we have co-chairs and co-vice chairs. Look at us. Okay. Next on the agenda, we've invited in the Office of Data Practices, and so we'd like to invite them to the table. The director of that office is Taya Moxley Goldsmith, and she is coming to the table. And we look forward to your presentation. We discuss what do we talk about in this commission, and rather than doing just a broad overview of the Data Practices Act, which Representative Feist and I both felt that the people on this commission are a little beyond just that overview, and we wanted to dig a little deeper into what the office does. And so what they're going to present today is a little different than that broad overview, and they're going to talk about opinions that they issue. They're going to talk about what the responsible authority, what their role is, and some other topics as well. Welcome to the committee, Ms. Moxley Goldsmith. Please introduce yourself for the tape and go ahead with your testimony.
Vice chairs and members, good afternoon. My name is Taya Moxley Goldsmith. I'm the director of the Data Practices Office at the Minnesota Department of Administration. And thank you for having us here today to talk about data practices. The vice chair or the chairs asked that we address a few specific items. So my colleague is going to talk about just general access to data and responsible authorities and roles that certain staff members have. And then I'll talk a little bit more about our office and what we do.
All right, and chairs, Casey Carmody, Assistant Director of the Data Practices Office, just for the record there. Okay, yeah, so I'm going to do a little bit of an overview of the data practices related laws, as well as what the responsible authority does on that front. And I'm just trying to see if we can get the... Okay, thank you. All right. Okay, so when we're talking about data practices, there are a variety of laws that come into play beyond just the Data Practices Act. And so some of the other laws that everybody does need to think about when it comes to data practices is the Official Records Act, that's section 15.17, as well as the Records Management Statute, which is section 138.17. And these laws interact with the Data Practices Act as part of what I would call the life cycle of government data or government information in Minnesota. And so your Official Records Act is the law that requires government entities to create specific information, specific records, specific data about their official activities related to their duties. And so really documenting the work that all government entities are up to. So that's the creation part of the life cycle. The Data Practices Act, which we're experts on, is going to be how you maintain those data, how you administer that data once it's actually in your hands. And so the Data Practices Act does a variety of things, including classifying data. So data are presumptively public unless classified as not public by a specific statutory section of the Data Practices Act or other Minnesota statute. But then it also provides rights for members of the public and data subjects to request that data and get access to government information. Beyond that, there are some additional requirements with the Data Practices Act, such as security requirements, requirements that the data that government entities maintain about individuals be accurate, current, complete, and secure. So just correct, essentially, about individuals, and folks have a right to challenge data that they believe are incorrect. Then lastly, you have the records management statute. This comes into play with records retention schedules. And so this is how long you need to maintain data over the course of the data's life. So putting together a records retention schedule, having that approved by the state, and then maintaining the data over the course of that period. And so once that retention period expires, then folks can destroy official records and move on from there. So that's really the life cycle of data, the creation, the maintenance, and then the destruction of records once that retention period is reached. So when thinking about the Data Practices Act and the various roles that government entity staff have with the law, there's a few important individuals that come up that are specifically described in the law. First is the responsible authority. And this is the person at each government entity who's ultimately responsible for the collection, use, and dissemination of all of the entity's data. Also responsible for all of the entity's data practices decisions. The responsible authority needs to make sure that the entity is complying with the requirements of the law, as well as the various administrative rules related to the Data Practices Act. If an entity violates the law, then it's the responsible authority who's ultimately named on that lawsuit and is held responsible. Okay, the responsible authority may also appoint designees. These are individuals within a government entity who are responsible for certain types of data or certain areas of data. A designee can receive data requests and process data requests on behalf of the responsible authority. Oftentimes internally, other individuals might be also working on data requests. I'll talk about that in just a moment. But the designee is a person who is authorized to receive data requests in addition to the responsible authority or beyond kind of the policies and procedures that a government entity lays out. This person does need to be appointed by the responsible authority. Oftentimes in government entities, it might be the directors of divisions or different offices or different areas within the entity. There is no obligation to appoint a designee. For some smaller municipalities where they have a very small staff, a designee probably doesn't make much sense. Larger government entities like state agencies, you might have several designees who are responsible for their various divisions or areas when maintaining data. Another individual that's identified in the Data Practices Act is the Data Practices Compliance Official. And so this individual is someone that the responsible authority is obligated to appoint who's responsible for responding to questions or concerns about an entity's data practices. So if someone reaches out to our office and says, hey, I'm having difficulty learning about the status of my data request, or I haven't heard anything for a while, or I don't think they responded appropriately, one of the people that we will often direct that individual to is the Data Practices Compliance Official. That DPCO is a person that's there internally, can answer those questions, check on the status of requests, and help answer some of those general problems or questions that folks might be having. One notable thing about the Data Practices Compliance Official is that it can also be the responsible authority. So the responsible authority can say, hey, I'm going to appoint myself as both as also the DPCO in addition to my duties as a responsible authority. One other thing I should note about staff with data practices duties. So these are folks that are specifically described in the Data Practices Act. However, I'd say that everybody within the government entity, all government employees do have data practices responsibilities. Everybody is obligated to secure data when working with not public data, making sure they know the classification of data, as well as occasionally being called upon to provide access to data or compile data responsive to a data request. For example, I'm not a RA, I'm not a designee, I'm not a data practices compliance official, but if somebody asks for all of Casey Carmody's emails, I'm probably one of the people that are compiling those data and helping make sure that we're responding to a data request appropriately. Okay.
Just going to pop in here and ask a question real quick. In your experience with your office, do you find that, like you mentioned, that all government employees have this obligation to know how to classify data, what to keep and what not to keep? Do you find that most of them are trained well in that? What is your experience at your office, if you have some in that specific way?
Chairs and members, I think that often there is a small group of folks that are the data practices folks that folks at the entity look to be their data practices experts. And so there isn't always that general broad training that everyone gets. What we suggest and the resources that we have is that all employees should maybe have 10 minutes a year just to say, there's this law, here are the people within our entity that are in charge of different duties. If you have questions, if you see something that says data request, here's who you should go to. So not everybody needs an all-day training, but if you're going to be a designee or a DPCO, you might need to come to a longer training to understand what your role is and your responsibility. And then the entity decides how to implement those procedures. And so they'll have to have some internal discussions as well.
Thank you for that. And then one other question I had, because you went over what the responsibility authority does, and then this other DPCO role. Some government entities are using a portal now for their requests, and it's very difficult for people to actually talk to a human being. And so is the use of a portal something that you all have recommended to entities if they've contacted you? I just have some issues with the whole portal thing, because I've used one myself and it's not great. So
Chairs and members, thank you for that question. It's definitely not something that we've recommended. I think it's something that entities are using to streamline some of the processes and make it more efficient. So it's not necessarily a recommendation. I think it's just a tool out there that entities have been using. There are people behind the portal. It is not a machine doing the work necessarily, but in terms of tracking, I think entities have found that useful to kind of automate some of that more administrative work. But the actual gathering of the data and redacting the data and looking at the data is all being done by employees.
thank you. And I just encourage members to pop in with questions if you have them. And I want to get through your presentation, but if you have questions, something that pops in your mind during the presentation, I appreciate that.
Yeah.
Representative Elkins.
Yeah, thank you. As part of this, can you just touch on somewhere along the way the role that Stacy Christensen and admin plays in this process?
Sure. I can just say now, she's the general counsel and the deputy commissioner for the whole Department of Administration.
But does she have a designated role?
Oh, I'm sorry. She is the DPCO for our
Okay.
agency.
Okay. Anyone else? Okay. Thank you for letting us. Oh, Representative Feist, Co-Chair Feist.
Thank you. I have kind of an esoteric question, but it just goes back to your previous answer about kind of what type of training people receive. As the kind of like what is data evolves as technology evolves and our interpretation of the law evolves. I'm just thinking about the question of like what are sticky notes, data that should be recoverable under a Data Practices Act request, and thinking about what type of training people need in order to know. Like I go through my email periodically and just delete really old emails. I guess the house isn't subject anyway, but like I'm thinking more my law firm. But like, do people know what they're allowed to just delete? Like there must be some type of training for like basic things. And are they told to keep all their sticky notes? Just kind of curious.
Director Moxley Goldsmith.
Chair Feist, thank you for that. Every entity has their own internal policies and procedures around how they do training and what is involved in that training. So every government entity has a records retention schedule, and they have to follow that schedule for their official records. So there's a difference between official records and government data. So government data is that broad, anything recorded that we're using to do our work. So sticky notes, yes, those are government data. Are they official records that become part of an official transaction? Probably not. Are you writing a press release on a sticky note? Probably not. Maybe you've jotted some notes down. And so when you don't need that anymore, you can get rid of it at any time. So general government data can be deleted at any time, but official records need to be captured according to your records retention schedule and kept. And how entities do that, I think, really varies based on the entity, the work they do, the size of the entity. Do they have a records manager? We used to have, there was a position at the Department of Administration in the 90s that was a records manager, and they served as a resource for the state for records management. Now, we are not records managers, and we talk about records management generally because it relates to data practices, but it's not part of our responsibility. That funding went away in 2000 and that position went away. So we don't have somebody who is the records manager, does what we do, but for records management. So we talk about it because it impacts data practices, but we aren't the experts on that.
Senator Limmer has a
Thank
question
you.
on that.
Director Goldsmith, or perhaps your assistant, the portal that Representative Scott mentioned, is that fired up by artificial intelligence, or is it a page that anticipates a question and then it's rather general information? Could you explain what the public might experience if they had a question like that?
Director?
Yeah, I'm happy.
Go ahead.
Chair, Senator Limmer. That's a great question. The portals that we've seen are various, proprietary portals, and we don't have a lot of expertise in kind of the nuts and bolts of each one of those and how they all work. I don't think I've seen a portal that is using AI or anticipating, questions or directing data requests. That would be a first for me to hear about that in my conversations with folks who have used portals in the past. That's not to say that that isn't happening or they don't exist. But there's a variety of different ones that we've seen out there. And so it's possible, but it's not something that has been brought to our attention, at least at DPO, about AI being used as part of that process to receive data requests or, facilitate compiling data or anything like that.
Senator Limmer, follow up?
Yes. In the event that perhaps the portal doesn't answer the question, that the user may be proposing, or perhaps they want guidance, or if it's a more complex thing, does anyone ask for a legal opinion from your office?
Mr. Harmdy?
Yeah. Thank you, Chair and Senator Limmer. We do advisory opinions, and there has been a couple of questions that people have reached out and they haven't formally requested advisory opinions on this particular issue. We do offer some general guidance when folks ask, but if somebody was having an issue with this, I think the recommendation that we might have is to reach out to the government entity to ask some questions about really complex data, what you might have, what they might not have. Alternatively, if a data request is submitted and there are some challenges with receiving a response to that or misunderstanding, occasionally staff in DPO will reach out to a government entity and ask for some clarification and some assistance. But, to the extent, and we'll talk a little bit more, I believe, about advisory opinions here shortly, but that question hasn't been directly posed to us in an advisory opinion request up until this point so far.
Senator Limmer?
Yeah, the question I have, and Madam Chair, if we have later in the presentation today a segment on advisory opinions, I can hold my question.
We are going to cover that, yes.
Okay, well, I'll hold back then and listen. to the
Okay,
presentation.
all right, thank you. Couple of things on the whole, the portal situation. What if you don't have a computer? I think that's something that needs to be, I mean, I don't know, I guess we could ask these entities that have the portals, how is somebody that doesn't have a computer supposed to ask for data? And what what another option might be, because, most of us do have these little handheld computers, but not everybody does that might be asking for some government data. So I think that's just something to ponder as we think about this. And then in the act itself, doesn't it talk about the responsible authority having to sort of keep data in an organized fashion so that's easily accessible and organized? Isn't that part of this of the act as well? If one of you wants to answer that.
Easily accessible for convenient use.
Right. And so I think that's an important point that the responsible authority has is, with today's technology, and Representative Elkins could attest to this, there are multiple ways that they can use technology to help organize that data. All right, let's move on.
Thank you.
I just have one more thing to your earlier question. I don't think I answered quite. So we're not necessarily recommending portals. I think what we tell folks is that they're not prohibited. So 13.03 says that they need to have internal procedures to ensure a prompt and appropriate response. And how they go about doing that varies widely, both. And so it depends on the entity, the resources they have, the amount of requests they have. But also to, I think, your last point about how do folks get in contact if they can't use the portal? The two things that we tell data requesters is that you can always write to the responsible authority, that the responsible authority, their job is to receive requests. So even if you have a portal, that there should be a mechanism for the responsible authority to receive requests. So we tell requesters and entities that there should be an opportunity for that. In addition, everyone has all government entities have Title II ADA requirements, and therefore they have to provide opportunities for folks who maybe can't use a portal for certain reasons, for disability reasons. So they have alternative measures, and so those should be available to requesters.
Yeah, thank you for that explanation. I think it would be good just to the places that have portals to look at the fine print to see if they do say somewhere, if you don't have whatever, please write us a letter. Put a stamp on it.
Yeah.
Okay, go ahead.
Thank you. Okay, so just identifying the responsible authority. So state law and the administrative rules do identify who the responsible authority is at different types of government entities. And for state agencies, typically it's the commissioner of a state agency, the constitutional officer for their respective elected offices, the chief executive officer, or an official appointed by the agency's governing body. So that's a lot of your licensing boards or multi-member bodies. At the school district, it is the individual who is appointed by the school board. If no individual is appointed, then it's the superintendent. At a city, it will be the person appointed by the city council, or if no one's appointed, then the city clerk. Counties are a little unusual because there are several responsible authorities. And so typically the elected officials for their respective offices, the county attorney, the county sheriff, they will be the responsible authority for their offices. For all data outside of those offices, so general administration, it's going to be the employee appointed by the county board or commission on that front. There's also some language in some other statutes or subdivisions that say that the county social services agency director is the responsible authority for their agency, and then the county veteran service officer serves as a responsible authority for their office. For other entities that come up, it's typically the chief administrative officer, so joint powers authorities or boards. Oftentimes that'll be the chief administrative officer for their specific office. Okay, moving on to access to data. So this is another area, as I mentioned, when it comes to the Data Practices Act, that's really a big aspect of the law, is the members of the public as well as data subjects being able to actually access data and obtain government information. And so when we're talking about access to data, what we really mean is either inspection or copies of government data. Inspection is going to a government office, looking at the data, whether it's in paper format or electronic format, and just being in the office, going through the data and inspecting it, and that's always free. Copies are what it sounds like, obtaining copies of government data. There are some copy cost provisions in the Data Practices Act related to obtaining copies, but that's actually walking away with some data or having it sent to you rather than going in person and inspecting. When it comes to requesting data from a government entity, requesters are obligated to follow their required access policies. Section 13.025 requires each government entity to have a data practices policy for members of the public, as well as for data subjects. Those policies describe how someone can request data and some basic processes around how that request will be processed. The data subject policy also should be explaining the rights of data subjects. So their rights are a little bit different under Section 13.04. So those policies should be readily available to the public so folks can understand how they can access data at a government entity. On the other side, when a government entity receives a data request, they are required to have internal procedures in order to provide a prompt and appropriate response. These procedures do not have to be written. We certainly encourage folks to write down these procedures to understand how to filter a data request or send it to appropriate folks. But there is no requirement in the law that says those procedures must be written. That's a little bit different than the access policies, which do need to be written. That's pretty clear in 13.025. Okay, just one other aspect that I want to talk about before turning it over here is some trending issues. So these are some things that folks are reaching out to our office a lot. And this is what we're hearing about from both members of the public as well as government entities and their staff. One of the big issues that we often hear from members of the public is about enforcing the Data Practices Act. It's probably at least once a week I hear from somebody in the public about how they can enforce their rights under the Data Practices Act because they have concerns about access to data. Now, sometimes those concerns, we'll explain and offer some guidance about the law, and it might not be a concern at all. Other times, folks say, "Hey, I just really want to go through this process." And so under the Data Practices Act, 13.08 and 13.085 are your remedies for alleged violations of the Data Practices Act, which requires you to file a complaint in district court or at the Court of Administrative Hearings. So these are legal processes that can oftentimes be complex. They may be expensive, may be time consuming. And so I talk with lots of members of the public who are generally frustrated with those challenges about those being the remedies to really enforce their rights under the Data Practices Act. Records management resources. This is another area where government entities talk to us a lot about because there is just more and more information that government entities are maintaining. The Data Practices Act is a little bit different today than it maybe looked like in the 1970s, where there's more electronic data, storing more information, receiving more information, and collecting more information. And so there are some challenges with managing records, ensuring that they're holding them for appropriate lengths of time, and just kind of balancing all of those records management requirements. We also do hear from government entities about larger data requests. And so more folks are asking for any and all data related to a particular issue. And sometimes that can be a substantial amount of data. And so folks are asking for that. And a lot of entities are seeing more and more requests for larger amounts of data. There is no language in the Data Practices Act that allows a government entity to deny a request because it's burdensome. And so there are some challenges there that we've heard about from government entities. On the flip side, we also do hear from a lot of members of the public about the length of time it takes to respond to data requests. And so the requirements under the Data Practices Act to respond to a public data request is appropriate and prompt and within a reasonable amount of time. Those terms aren't defined in the law, and so it is variable depending on the complexity of the request, the amount of responsive data. And so we do get a lot of questions where someone says, "Hey, I asked for data from my local city. It's been 2 weeks. I haven't heard anything back." And then we say, "Well, what have you asked for?" And it'll be, all emails since, 2005. That's going to take a little bit of time for maybe the entity to pull together. But other times it's been 30 days or 60 days. And it's a relatively straightforward request, and maybe a requester hasn't heard anything back. And so that might be a situation where we'd reach out to a government entity and say, hey, what's going on with this? But I think there's a balance here. Larger data requests, the amount of time, both sides, so the government entities and members of the public, I think are finding challenges on that front. And then lastly, law enforcement data. This is an area that we probably do most of our work in, speaking with law enforcement agencies about the various requirements related to data under 1382, as well as a host of other requirements related to body camera data, drone data. There's all sorts of miscellaneous statutes that may be coming into play, property complaints that law enforcement agencies need to know about and are having some challenges with because the law is becoming more complex in these various areas. Body camera data, also 13.825 is an area that we hear from a lot of folks too about challenges with redaction. There's more body cameras out there now, more requests. I think folks are more aware of body camera data. And so responding to requests takes a substantial amount of time because there are redactions that need to be done. And there's a lot of data and images to go through. If there's three videos for an hour, each, that's 3 hours of data to review, redact, and process for just one request. And so there are challenges there.
Okay.
So those are,
Go ahead.
those are some of the big trending issues that we've been seeing, at least recently, but I can pause there.
Right. I appreciate you responding to that request to just like, what's trending? What are you hearing about? So thank you. This is very helpful. Representative Feist.
Thank you, Madam Chair. I just wanted to mention that I'm working with Representative Duran on the body cam statutes and trying to look at some of these technical updates that we might want to make. Because I know, like everyone else on this commission, we get all of these emails. And for years, I was like, oh, I should look at these emails. And I kind of didn't. And I feel I shouldn't maybe say that publicly, but I was just like getting them and kind of overwhelmed. And so then I started looking at them and I was like, what are these? And they're all formatted slightly differently. And I was like, what am I supposed to get out of all of this information? And so I've been just kind of looking into that, and Representative Duran also happened to be. And so we've synced up. So if you have proposals for technical updates that can address some practical concerns and still achieve the goals. And also just looking at, like, I was like, what is the goal? Like sometimes the goal is just to make people do the paperwork and that somehow achieves the goal. But I was like, if the goal is for us to really understand what we're looking at, I don't think that's being achieved personally. So would love to engage with your office on that. Thank you.
I just wanted to follow up on the larger data requests, because probably everybody around this table has experienced a constituent contacting them, or a government entity who's frustrated with it. When you get a government entity that contacts your office and say, somebody asked for email from 2005 to present, what do you tell them?
Chairs and members, we say there's no overly burdensome exception to this law. So you have an obligation to respond to every properly submitted data request. That data request is going to take years probably to respond to, and that is probably a reasonable amount of time. The time, as Casey was talking about, is really in the redaction. There has to be eyes on every single email to determine whether there are any not public data. So what we tell them is break it up into manageable pieces. Get a schedule, get an idea, do a general search, get an idea of the amount of data you're talking about. So maybe do a month and a year, and then extrapolate what that's going to look like for all the years. And then come up with a schedule, start rolling it out. And then there is that new language now in 13.03 that says, if somebody is coming in to inspect or get copies and they don't within a certain amount of time, then the entity can suspend the request. And so they have that tool to use now, but ultimately we say you have to respond. So start getting an idea of what responsive data looks like, set a schedule, and then start rolling it out.
And thank you for that. And do you ever tell them, why don't you work with the requester, let them know that it's going to be this amount of time. And if you want to get, your information a little more readily, is there something that we can do to narrow the request? Do you ever give that advice as well?
Yes, absolutely.
Okay.
Yep. But
perfect.
it's not and we tell them, for entities, yes, have that discussion if the requester is willing to have that discussion with you. If they're not, they can kind of stick to their guns and stay with the request as stated. But, you know, a lot of times folks do want the data and they don't necessarily know how government is maintaining it. So having those clarifying conversations is really helpful for the government to say, well, this is how we have it. How you've asked for it will result in this amount of data and this length of response. If we can talk about what it is, you know, we can get to a more discrete set of data, then they'll have less to look at and, you know, the government will have less to provide.
Right.
So definitely important to have those conversations.
Right, right. And as you said, if they don't show up, if they're just wanting to view the data, because nobody's going to want to pay for that much information for copies. If they don't come within a certain number of days to review the data, then they can suspend the request. And so it's not, the entities do have some options rather than, oh my gosh, how am I going to fulfill this request, right? So thank you for that. Any other questions from members at this point before we move on? Okay, let's go.
Okay, now we're going to talk a little bit about what our office does, and there are a couple specific functions that we were asked to talk about, so we will definitely talk about those. We are a small but mighty team of 4 at the Department of Administration, and we're a statewide resource on data practices and, to a lesser extent, the open meeting law. The bulk of what we do really is around the Data Practices Act. Most of what we do is respond to questions, phone calls, emails about the Data Practices Act, both from members of the public and government. We provide training, we do advisory opinions, handle applications for temporary classifications. I don't think we've ever had an application for a new use since I've been working here. Data challenge appeals, legislative assistance. So these are just some of the things we do. And here is the statutory authority for each of the things that we are tasked with doing. Some of these are for the Commissioner of Administration, and we assist her with those responsibilities. So we're going to talk specifically about advisory opinions and training and how we do those. So since 1993, the Commissioner of Administration has had permissive authority to issue non-binding advisory opinions on issues related to data practices, and since 2003, related to the open meeting law. As I noted in Section 13.072, it says they are non-binding, which means that people don't have to follow them. They are supposed to be given deference in court in actions involving the data. That sometimes happens. I think if the opinion supports what the court is trying to do, then they go with it. If it doesn't, then they don't. It also provides some legal protections for individuals and entities that rely on an advisory opinion. So if an entity, as Casey mentioned, the enforcement mechanisms are really through court. So if somebody does go to court or the Court of Administrative Hearings for a 1308 or 13085 action, they may receive a prevailing data subject or a prevailing data requester may receive attorney's fees. If they have an opinion, then they shall receive attorney's fees. So if there's an entity that has an opinion and that they rely on, it doesn't have to be to them specifically. Any of the 1,000+ opinions we have, if they rely on one, then they have certain immunity from attorney's fees and other remedies under 1308. So the identity requester determines what kinds of questions they can ask in an advisory opinion. A government entity may ask any question relating to public access to government data, rights of subjects of data, or classification of data under Chapter 13 or other Minnesota statutes governing data practices. So a government entity can ask for an advisory opinion. They can ask a hypothetical question. They can ask a general question. They can ask a question specific to a situation that they're involved with. A member of the public or a data subject, when they're the requester, it says any person who disagrees with a determination regarding data practices made by a government entity, the commissioner may give a written opinion regarding the person's rights as a subject of government data or the right to access government data. I'm missing an A there. So what that means is a data subject or a data requester may ask for an opinion, but they have to have a determination from an entity that affects their own rights as either a data subject or as a data requester to access data. So there's slightly different scopes in terms of what what the opinion requesters can ask for. Examples of answers that they might get back from a government entity that they get. Just kind of that last sentence that you spoke of. Yeah, what kind of questions? They can ask for, so if they are asking for public data and they don't get it, they can ask for an opinion on that. If you're a data subject, a common one that comes up is, I'm a data subject, I asked for data, I didn't get it in 10 days, so there's a 10-day business requirement. That's a determination by an entity. If there is a classification, if the entity is saying that data are classified in a different way, that's a determination by the entity. And maybe the requester is a reporter, if they're saying, well, we think it's public, so we're challenging that determination that it's private. So that, those are some of the things.
Yeah.
Okay. Okay, so what do we do when we get an advisory opinion? First, the first question that we really ask when we get something, an advisory opinion request, is whether or not it's in scope. So we look at 13072 and say, is this something that the commissioner can even say something about? So for instance, if we get an advisory opinion request that says, I asked for data from a non-metro township and they didn't give it to me and I want an advisory opinion. Non-metro townships are not government entities. They're not subject to the Data Practices Act. So that's outside the scope of something that the commissioner could talk about. If someone is asking about someone else's right to get access to data, that would be outside the scope of 13.072. So those would be just no's, but we would explain, we would say, no, we're not going to do this advisory opinion, but then we might have a conversation with them about why we're not doing it and why it's not in scope. And are there other ways that we can help them do that? Then we also look to see when we're evaluating, is there a violation just on the face of the document? So of the request. So we look at the request and we say, does the request assert a violation? So occasionally we will get something that says, I requested public data and they didn't give it to me in 10 days. Well, there's no requirement to give it in 10 days. So that's not, there's no violation on that request. So we would say no to that. And then again, we would have either in the letter or have a conversation with them. It's not 10 days, but tell me how long you've been waiting. What can we do to help you with that situation? Then sometimes we don't have enough information in the request and we need more. We have 5 business days to decline. So oftentimes we can't get all the information that we might need in that 5 days. So we just say no. And then we say, we need more information to assess your request appropriately. Sometimes we lose people there. Sometimes they don't come back and we don't chase them. So if you don't come back with your information, it's just declined.
So if they come back does the 5 days start over again? If
They
they
have-
provide the information you need?
What we would ask is if they ask for another opinion, then the clock is starting over. But if they just come back with information, we'll work with them to get their stuff in order before they kind of officially submit their request.
Got it. Thank you.
And then we're on that 5-day timeline. And then, so if we accept the opinion, if there's an opportunity to resolve it without an opinion, so the ones that we've kind of talked about, I submitted a request, but I didn't get an answer. Those are ones where folks might ask for an advisory opinion, but we need a little bit more information about who did you ask, when did you ask, was it a properly submitted request? And those ones we can generally just resolve with a conversation, either with the requester or with the requester and the entity. Because again, if it's somebody says, well, I made the request 5 days ago and I haven't heard anything, we might say, well, you might need to hold on a little bit and wait. Or they might say, I sent it to someone who is not the responsible authority or a designee, in which case they haven't made a data request. So we might have some back and forth with them about what they need to do in that case. So if we can resolve it in that way, then that's much more efficient than writing an opinion about it.
Director, does your office have a list of who all the responsible authorities are? No.
We do not. No.
Okay.
So we Google and we look for their access policies. Most entities, a lot of entities, I should say, have their access policies online, so we can identify the folks that we need to contact. We generally will go to the data practices compliance official first, because that really is their role to act as the liaison with the public, and that's kind of who we are as well. And so we go to that person first if we're trying to resolve something and say, hey, we have a requester and we just want to see what's going on here, if we can learn more. And sometimes from those conversations, it is going back to the requester and saying, you're not going to get all the data, because we understand that when a requester comes to us, we're getting that side of the story, but we're not necessarily getting the whole picture. And so once we have more information, we might say, these are the classifications they're relying on, and I think it's reasonable that they're relying on it, so you might not get it. Or we might say entity, what's happening, and they might say, oh, we are responding, we're getting this, we're going to have it out to them by X day. So then, we can resolve it that way.
Okay, I think Senator Limmer has a question. Go ahead, Senator Limmer.
Yes, thank you, Madam Chair. I know that oftentimes legislators, their eyes glaze over when we start talking about data privacy and where to find it in the statute books. And I can only imagine how difficult it can be for a common citizen that's trying to, well, either try to avoid pitfalls in whatever they're doing, and they're asking for opinions from your office. Are there a lot of requests for opinions? And then of that, could you give me maybe a ballpark idea of is it common to give an opinion, or do you just, I would imagine there are some times when you just don't give opinions. Could you give me a breakdown on how many requests there are, let's say, in a year, and how many are given opinion versus not?
Director.
Okay. Chairs, Senator Limmer, thank you for that question. So let's see, this year we have had thus far 75 requests, and we have accepted 11. And that's increasing. So in the last few years, what it looks like is we've had 75 in 2025, 64 last 2024, 55 in 2023, 44 in 2022. But I think the important thing that I would like to note as well is that advisory opinions aren't the only way that the public interact with our office. The most of our interactions with the public are just requests for technical assistance and questions. They don't have to occur in sort of the formal advisory opinion structure. We answer a lot of questions each year. I have a slide at the end that talks about that. But
And one thing I would just add about all of our advisory opinions, when we say no to an advisory opinion, we do offer some technical assistance or guidance. And so we send a formal letter to everybody that's requested an advisory opinion. And that letter usually states the legal authority that the commissioner is operating under, as well as some general guidance about how Chapter 13 operates, or other reasons why the opinion is not moving forward. Oftentimes, we'll work with the requester and say, hey, there is some information here that maybe is a little puzzling to us, so we'll reach out to the government entity and have a conversation with the government entity about the status of your data request or how they responded to your data request. And so we don't ever just say no and that's it. It usually is at least some formal guidance, and that can stretch on to 2 to 3 pages at times, depending on the questions that are raised, offering some guidance about the requirements of the law.
Thank you for that. And then I know you mentioned how many requests you had in 2024, 23, and 22. How many advisory opinions did you do each of those years? Do you have that, please?
Yep, 2024, we had 64 requests. We issued 4. 2023, 55 requests, we issued 5. In 2022, we had 44 and we issued 6.
Okay, thank you. And I don't know if you keep track of any of this. You most likely don't, but if you do have this information, I'd be interested in it. How many times when you don't do an advisory opinion does a person go on to the next level, either district court or the Office of Administrative Hearings?
I don't think we have that statistic, but I think we are seeing more activity at the Court of Administrative Hearings, but it's still pretty rare for folks to use either of those.
Okay, and could you remind me of what the filing fee is at the Office of Administrative Hearings?
It's $1,000 for that, and the plaintiff has to substantially prevail to get that money back. And
Right.
so even if they prevail, but it's not substantially, they don't get it back.
Yeah, I mean, I think that accentuates the importance of your office to help the public and government entities too, right? So they can avoid that. I mean, most people just don't have $1,000, laying around to go to court with. And that's just where it starts. So, all right, go ahead.
Yeah, and so, so these are the other steps that we take when we're in that formal process. And when we talk about it, when I talk about advisory opinions, what I like to tell folks is that they are exactly that. There are non-binding advisory in nature. They're meant to provide guidance. They have limited legal effect. And so if we can accomplish something within a couple calls or emails versus a 2-month process to issue a formal advisory opinion, we definitely, for efficiency's sake, try to accomplish it through more informal process rather than issuing advisory opinions. When we're looking at advisory opinions and ones to take is, can we provide additional guidance on a subject? Is there something we haven't talked about before? Can we push an analysis a little further? Is this a novel situation that hasn't been addressed in the 1,000+ opinions that we already have? So those are some of the things that we think about when we're trying to determine which opinions can we accept or will we accept and put to formal opinion. So that's, yeah.
Director, thank you. I'm just wondering, what would be the effect, in your opinion, and I don't, maybe you haven't given this any thought, but what would be the effect of making those opinions binding? So that person didn't have to go to that next step.
I think that there would need to be a full structure built underneath for enforcement of that binding opinion. So just making it a binding wouldn't do anything without having both, kind of the stick end of that, of like, if you're not complying, then there's going to be the consequences. And then who enforces that and who has the resources and the statutory authority to do that enforcement. So I think that advisory opinions were meant to be a way to have sort of a type of enforcement, but ultimately, because they're non-binding and they don't really have, folks aren't required to follow them after they're issued, they don't have that enforcement effect necessarily. That
Thank
maybe
you
we're
for
told.
taking a stab at that. I appreciate it.
Okay, I'm going to turn to training now, but if you have questions on advisory opinions, happy to continue that conversation. So again, one of the things that we do is provide training, and we provide it in several different ways. And we are required to provide a training program. So we have workshops that we do on specific topics that are half day, all day. Again, not every government employee needs to have half day or all day, but folks that are working with us all the time. These are the topics where we see the most questions, and we've developed curriculum for these particular things. So we have an intro to data practices for responsible authorities, designees, DPCOs, folks that are doing data practices at their entity and formulating those access policies and procedures.
Director, thank you. I'm sorry. Representative Hudson, before we get on with the training, I think you had a question on the previous section. Yeah. Go ahead.
Thank you, Madam Chair. Yeah, going back to the advisory opinion piece, I wanted you to get through it before I asked the question. And it seemed like you touched upon one of the questions that I wanted to ask, which is the extent to which your library of previously established advisory opinions serve as a kind of a precedent of sorts that you rely upon, both to determine whether or not you're going to issue a new one, but also what that new opinion could look like. Is that a fair summary of the process?
We do look at the old ones and build upon them or rely on them, both in deciding whether to take one, and also then when we write one, we use the analysis that is existing already.
Representative Hudson.
Thank you, Madam Chair, and thank you for that answer. The other question that I had was, there's obviously a pretty significant ratio of requests that result in an advisory opinion as opposed to the ones that don't. And you sort of addressed that in terms of try to look for efficiencies and find ways that are less burdensome on all parties to try to resolve the situation. And this is a somewhat subjective question, but in your observation, how often does that process, when you're not going to issue an advisory opinion, end up in what the requester for that data would consider to be a satisfactory resolution to their request?
Director.
That is a hard one to assess. I don't have numbers per se, because sometimes a requester might be dissatisfied with the answer because they don't agree with our office. And so they're dissatisfied with the process because they don't agree with us. That perhaps the entity didn't do anything wrong in that circumstance. On the other hand, sometimes we are just able to get some data for a requester, and then they're very happy with that. So I don't have hard numbers on that.
And I'm happy to offer an example of recently where we worked with this, where I was working with an attorney at a law firm who requested an advisory opinion. She was representing a former employee who had asked for all disciplinary data about that employee. So basically, requested data about why she was discharged. And the city that they were asking for the data from basically said, well, no, we're not going to provide you with the substance of those complaints because it's data about other people. I think we all thought that was incorrect analysis by the city's part. And so, rather than just immediately proceeding with the advisory opinion, we did speak with the law firm and offered this informal resolution process. And then I spent probably about an hour providing some education to the city and their attorneys about that. And our position was that those data are probably available to that former employee, and had some conversations. Also probably help reset kind of maybe a tense relationship between the law firm and the city to some extent. And the data was provided. And I think that law firm was pretty happy with, going through that process in a matter of about a week and a half and actually getting the data in the end, rather than sitting through 50 days of wondering what the outcome might be, and then potentially getting the data after that. So that's just a practical example.
Thank you. Thank you. Representative Hudson, are you good? Okay. Representative Feist, Co-Chair Feist.
Thank you. Yeah, I was just going to mention, I was just looking around on your advisory opinions website, and it does look like you side with the requesters. Like the small sample size of the ones I've looked at, looks like they were able to get the data that they had requested and that their interpretation of the law was accurate. So I don't know, it was a very interesting website. I'm going to go down this rabbit hole some more.
You. Sometimes people ask about, because the opinions are going to skew towards the requester, because again, if there isn't a violation on the face of the advisory opinion, then we don't take those. So don't necessarily take the ones where we would just say, oh yes, government did exactly the right thing. We're generally taking them when there has been a violation, or that it looks like from the face that there's been a violation, and then we ask for comments from the entity, and then they give why they acted in the way that they did. And sometimes that's persuasive, sometimes it is not. And sometimes they say, yes, we made a mistake and going forward, we'll do better. So they will skew in that direction. Yeah. So these are the workshops that we do. These are a combination of lecture, exercise, small group discussion. They're usually about 30, 35 folks that are doing this work, and they usually involve 2 people from the data practices office conducting these trainings, so half of our office to do those. The bulk of the training that we do are free webinars and presentations. We record our webinars. We have a YouTube channel where we put those up. We have a short video of what all employees need to know about data practices. It's like 7 or 8 minutes, and we always suggest that for entities that they can show that at a staff meeting. There just aren't enough of us to go around for training. We do get requests by entity, by city, by school district to come to their staff meetings, and we just cannot do that. And so we have tried to develop some resources that they can do some kind of self-help, but also we're here to answer questions. So they can reach out to us at any time, or we can follow up after they've kind of had their staff meeting discussion. We also partner with a lot of other entities to put on trainings, free trainings. So the MSBA, which here would be both the Bar Association and the School Boards Association. We work with both of them, the AGO, charter schools, clerks. So we're trying to reach as wide of an audience as we can. Casey and I were just in Wilmer on Monday doing training for law enforcement folks. And so we are out there in the community, and we also are remote, which is great because we can we have a wider reach. So I think, let's see, we have, yes.
Yeah, I really appreciate hearing about this. And do you keep track of how many trainings you do? Like we did so far in 2025, we've educated 20 school board associations or administrators or whatever. And then also on the online training, you have a way, I'm sure, of tracking who's accessing what training videos. And so do you have some data that you could provide this commission on
Sure.
who's watching what and to what extent? Yeah.
Yep. And I don't have necessarily the YouTube views, but generally, yes, we track the trainings that we do and how many folks come. So in FY25, we did 12 workshops and we did 27 presentations, but total we had 2,317 attendees. So we're reaching a pretty good audience. So I have numbers for all of these and I can give them to you. FY24 was 2,388. But we have a spreadsheet that we can also share that will show who we're partnering with when we're doing those partner ones, when they're webinars that we're hosting, how many folks came, things like that.
That'd be really great. Thank you so much.
Let's see. So that's training, but again, if you have questions on training, we do a lot, and the demand for training is just always going to outstrip what we can do. And so the training is the one thing that we can really control how much we do. We can't control how many opinion requests we get or appeals we get or things that are coming into us that we have to respond to in a certain amount of time. But training will ebb and flow depending on the other demands of the office. So the primary work we do, as I mentioned, really is answering questions over email and phone. And so let's see, for FY25, I'm getting our numbers together. We fielded over 1,900 contacts last year on various topics. Casey noted some of the topics that we've talked about. Law enforcement data, again, by far our most prevalent topic that we respond to. So these are questions from government about how to respond to requests. What if we get that big request and what do we do? What do you think about this classification? We talk about, sometimes we'll get a question that just says, do you think this is a request? We'll get a lot of questions from members of the public about sometimes just how do I make a request to, and then they say the entity, and we try to just troubleshoot with them and try to find the access policies for that entity. Could be I've made a request and I don't understand this response, and then we'll talk about that. So that's really the bulk of what we're kind of doing day to day, while we're also doing that other list of things that we are responsible for. So that is what we do. Working on the FY25 annual report right now. We voluntarily just put together some statistics in an annual report each year, so you can take a look there on our website. These are where all our resources are. And the ways that you can contact us. We are here to talk about data practices all the time. So we are available to you and to anyone.
Thank you so much. And for us data nerds here, we really appreciate what your office does. And you mentioned that you can't be everywhere at once, obviously, and you get more requests for actually what you can handle as far as training being there. Is there a common thing that people want the training for that you don't have a YouTube video for? Because it seems to me like they could, default to that. If you aren't available to go to Wilmer and give presentations and training, I'm assuming that you direct them to the online. But is there something that you're missing? A topic?
That's a
Perhaps,
great
I don't know.
question. There are occasionally requests for topics that are very specific that maybe we don't feel like we're the subject matter experts to do. So one of the things that we sometimes do is we have DPO presents and we partner with like the Safe at Home folks at the Secretary of State's office, and they came and did a presentation about how that program works and how entities can use it and how people can use it. So we track our contacts, who calls us and what their questions might be, so that we can say where are the areas that we should be directing our energies in terms of the resources that we should be doing. So we've had a lot of requests recently for expungement training. And I will tell you that we are probably not necessarily the experts for expungement training, but there is a very significant overlap with data practices. And I think there are some things that perhaps will be talked about during session this year to shore that up. So we're always looking for those opportunities to kind of provide other resources and yes, be able to point them to something because we can't be there.
Perfect. Any other member questions that you have? Co-Chair Feist.
Thank you. So I have two questions, but I can spread it out. One is very specific and one is just like really vague, just kind of curious. And I don't know that I have an opinion on this first question, but I'm curious what your thoughts are. Do you think that we should have a provision that relates to requests that feel overly burdensome and expansive? Like, I don't know what I think, but I'm curious what you think.
That's a great question.
Director.
So I give my general legislative answer, which is we generally try not to take a policy position because we are helping the public and we're helping government, and going one way or the other really goes into one camp. It is something that entities really would like as a tool to use as they're dealing with more and more data. I think it's also something that the public is very resistant to having. So it's hard to find a balance because no matter what, you'll be tipping it. So ultimately, the legislature makes those determinations.
Thank you. So my next question is just more expansive. Just the nature of data has changed so much since the 70s. And so I'm just curious, in your respective tenures with the office, what are the biggest changes that you've seen in that time with data practices requests?
Sure.
I think one is really how we do business now is different. It's not as it was contemplated in 1974 in terms of going to a filing cabinet and having a discrete file, copying it and giving it to someone. The ways data are being maintained are much greater, not just the amount, but the types and the formats. So we're seeing requests for formats and for things that we haven't thought about, and the copy cost structure and the timing structure are all related to an older way of doing business that maybe isn't reflected now. And so the question is always in terms of sustainability of the Data Practices Act, or whether those foundations continue to support the current way that business is conducted. So I think that amount is the amount and the types of data have changed a lot.
Yeah, and the other thing I would just note is there are specific areas that it seems like the questions have ramped up, and I've been with the office for a little over 5 years, but body camera data is, would get an occasional question here and there, but I mean, it hardly feels like a day goes by without answering a question about 13.825, whether it's a member of the public or a member of a government entity. And I would just add, just say ditto to everything that Taya has said. One of the strengths, I think, of our law is, though, that the definition of data, I think, is pretty good and it's pretty flexible. But on the flip side, there is a lot of information out there, and more than what was probably contemplated in 1975. And so I think that's both the strength and some of the challenges with the law as a whole.
You have a follow-up?
No, it's really interesting. And I think the word sustainability just really struck me. Like, we don't want our laws to just collapse in on themselves because they become untenable and unimplementable, practically speaking. So that just struck me, and I'll be thinking about it. Thank you.
And I just want to say too, the Official Records Act, when was the last time that was significantly looked at? And I know I've tried to make some changes with that because it was written in the 70s when people were getting a pink slip. Hey, while you were out to lunch, so-and-so called, right? That's what it was back then. And it's so much more than that now. But I think that act really needs to have some attention paid to it. And the problem that we find ourselves in here is there's no specific full committee, which it would take to really look at that and get the right stakeholders to have input to make it so that it's effective for both the user and the requester. And so I just feel like in many ways we've fallen behind on some of this data, retention, how long you have to keep something, how it's kept, all the things, right? So it's a different world than it was in the 70s, and we need some time to really delve into it. Representative Elkins and then Senator Lucero.
I was just going to say, isn't that our job?
Well, it is. Last year we met twice. Yeah. So yeah, I mean, our world has changed, right? This issue has taken over our world, really, if you will. So yeah. Senator Lucero.
Thank you, Madam Chair. I raised my hand initially because I just wanted to thank the comments there of the testifiers, because what they said is exactly what I would expect from members of the executive branch, and that is when asked the question, do you have any recommendations, et cetera, they are deliberately trying to be impartial in their capacity of executing the public policy that we as a legislative branch pass. I wanted to thank the testifiers for that in having that mindset, because it does disturb me over the years when members of the executive branch come forward and they are lobbying for one thing or the other when it comes to various policies. And I think that's an overstepping of the bounds in many cases of the separation of powers. So I just want to thank that. But since I raised my hand, then another comment, I just wanted to tie into what was being said here in terms of this issue. So if we look at our committee structure right now, we have committees that we as a legislative branch, we form these committees based on what are the impacts of the different topic areas in regards to the public. So we have the Transportation Committee, the Judiciary Committee, the State and Local Gov Committee, the Taxes Committee, the Ag Committee, the Veterans Committee, and it goes on, Health and Human Services, because these topics, these policy areas have major impacts and they need committee members to look at them as we are forming or tweaking policies in these various areas that are impacting, again, the public. As was just highlighted, since the 70s, artificial intelligence, data practices as a whole, the amount of data collection, data harvesting, data mining, data sharing, the amount of robotics, it is now as much of an impact policy perspective on the lives of Minnesotans as transportation is, as human services is. And so that's why I wholeheartedly am in favor of a committee having jurisdiction over these areas, because advancements are happening, innovation is happening, data harvesting is happening, data handling is happening, but is it happening contrary to what we would want as a public policy? So anyway, just throwing that out there as well, doubling down on what Madam Co-Chair you had suggested.
Thank you, Senator Lucero. Senator Limmer.
Thank you, Madam Chair. While we're on this subject, I was very concerned about the lack of meetings in the last few years. Is it the intent of the chairs to have regular meetings regarding our Data Practices Commission responsibilities? I agree with the comments that have been made so far. When we stall for a year or two, the corporate world, the government world is launching in quantum leaps ahead of us. And it takes so much time, so much understanding, trying to catch up. And quite honestly, we can't. Things are moving so fast. And here we're on the threshold of artificial intelligence that will be embedding itself in almost every aspect of what we do. Jobs are going to be lost. Data privacy intrusion will be made because of the speed coming at us. And I just hope we can have the assurance that the chairs are committed to having regular meetings because we cannot stall on this responsibility. And especially when we don't have a policy committee that's dedicated to data practice and some of the technology that is now coming at us. We used to have a data practice subcommittee in Judiciary. Just as a little history, it's very hard to find legislators that have the focus and the interest on it. But this is our new world, and we've got to be on top of it. And I really hope that there's a commitment from the chairs and from the members that we really have to put our nose down and do whatever we can, because if not, if we don't have proper laws protecting the public, civil rights are going to be denied or intruded on, and that is a very responsibility we have. So I hope we have a renewed sense of commitment from this commission.
Thank you, Senator Limmer, and I'll pipe in here, and then I'll let Chair Feist, Co-Chair Feist pipe in too. But we've kind of planned out at least for 3 more meetings, and hopefully we can squeeze one in December, but I would think certainly we can get one in November, hopefully one in December, and one in January. We don't come back till February. And so probably, it's, as we all know, even the best intentions of meeting during session, we have those best intentions, it's really difficult to do. And as Ms. Olson here found out, it was difficult just to get us all nailed down, just to have this meeting. So I think it's going to require a little more flexibility on all of our parts, and setting aside the time to make this a priority. And, talk about maybe one of the things that we talk about is what can we do moving forward to make sure that this is given more priority in the legislature, because it does Health and Human Services. Every aspect of our government that we have a committee for deals with this subject and they're going to be dealing with AI, they're going to be dealing with all the advancements. And so to that point, we need to be doing our work on this. So Co-Chair Feist.
Thank you. Yeah, I mean, and it's frustrating because a lot of these bills do like a pit stop in judiciary, and then we have to rush through them. And one of my goals is, and our shared goals that we've talked about, is to use this commission time to talk in more abstract terms about what are the challenges that we're seeing, what are some opportunities with technology as it advances, and to have those conversations separate and apart from specific legislation, and to give it the air that it needs to have, like more in-depth, thoughtful conversation. So I'm excited for those. We can, I have some bills that, we could hear bills too, but I'm excited for the really big picture hearings that we've talked about. So yeah, I'm really excited to have lots of hearings. I'm sure everyone is.
Thank you. Representative Hudson.
Thank you, Madam Chair. I'm going to do something that's a little bit dangerous in an open hearing and toss out a completely unvetted idea that just popped into my head. The term artificial intelligence has been raised a number of times through our conversation here today, and it occurs to me that the way most people interact with artificial intelligence is through these large language models, ChatGPT, Grok, et cetera. And it occurs to me that that technology would be very well suited to administering some of these data practice requests if we had a database of government data that it could be trained on, and you had policies in place. Like, for instance, when you put in a prompt to ChatGPT, if it violates their policies regarding copyright or something along those lines, it will deny you the request. And you could similarly train an AI to redact data on individuals or data that's inappropriate to provide for somebody. And instead of it taking however long it currently takes for somebody to manually go through and look at the stuff, it could kick out a result. And you would obviously want somebody to review that to make sure that it was in the scope of the law, but it could really cut down on the time and the workload that these folks have to deal with. Just an idea to throw out there.
I think no topic is out of the realm of discussion in this committee, because technology is like a rocket, right? Right now, it's not on some level trajectory, even a slant, it's like straight up in the air. And so I think what you're suggesting is to feed ChatGPT the Minnesota Data Practices Act and ask for the best policies. But no, I say that in jest, but in all seriousness, that may hold some answers for us, and it's a wild world out there. And I mean, every week we're hearing of different news stories. A couple of weeks ago, we learned that there are some law enforcement agencies in the state of Minnesota that are using AI to review body cameras and write up the police reports instead of the actual officers doing that. So, these are all things that, it's a massive task, I guess is what I'm saying. But if there's an efficiency that we can find through AI, I don't know. I have levels of skepticism. I mean, we are human beings, but I understand, maybe not the shortcuts, that's probably not the right word, but how can we use that in a powerful way that that will help us. Representative Elkins.
Yeah, I'll respond to that question first. So there is a flavor of artificial intelligence called retrieval augmented generation, or RAG for short. And Senator Rest has already initiated, examination into whether we could, basically point one of these tools at the whole Minnesota statutes and all of the research documents that have been created by House and Senate research. And do exactly that kind of work to make all of our legislative staffs more productive, and folks like these more productive as well. So that's something that is actually already being looked into. Yeah. So and then otherwise, I mean, the last time I had actually pulled up the chapter 13 and looked at it, it was 135 pages long. And I just pulled it up to see what it is now. We're up to 190. And a lot of that is because we have this general presumption that all data is public data unless it's otherwise exceptions to it in here. And so we now have, 150 pages of exceptions. And it's occurred to me as I was doing my work on my consumer data privacy law that I've encountered over the years cases where looking at locational data in particular, it's one of my particular passions, but we would, pass a bill that would say the data about your transit trips collected by a transit agency are private, private data, private non-public data. And we have stuff like that all over the place now. And it occurred to me, why don't we just have a general principle that a person's private, precise location or precise information about our travels is just generally private, non-public. We could probably clean out about 20 pages in here just by that kind of a change. And there's probably a number of subjects like that where we could make a change to the general rules instead of keep adding to the exceptions.
And I like the way you're thinking here. And I'm sure that you would support my bill. And what I tried to do is think about what are just some general frameworks, some general principles that we could put in statute so we don't have to add pages to the statute books. And that was just something as simple as if you want to share data, you're going to have to create audit trails. You're going to have role-based access, some of those basic things, right? And so, but I even got a little pushback on that bill. So I just feel that, and every single new piece of legislation that we write where they're sharing data, we add those things.
Mm-hmm.
It's just adding more words. And so if we just said this must happen, if you want to share data, just know that you have to do this. And the technology, as you know, exists to do it.
And there are general principles of, best practices for the handling of data. And they include, principles like data minimization. Don't collect data if you don't need it.
Mm-hmm.
Data retention. Don't keep it longer than you need it. And I think we should be generally observing those best practices in here.
Yeah, and I think there will be some differences between public and private, in the public sector versus the private sector and what they do. Because we know the value in government of having data held longer so that we can go back and find the origins of decisions that were made and that sort of thing. And I want to get back to, I think Senator Lucero and Senator Limmer also want to chime in. I think we have this room till what, 4:30? Okay. Senator Lucero, I think you were first.
Okay, thank you, Madam Co-Chair. And I know we're kind of talking about two conversations at the same time, but I just wanted to add on to the conversation that necessitates a committee and how rapid technology is changing. So here's a headline from September 29. So we're talking 2 weeks ago. China installing nearly 10 times as many robots in factories as the US. And so the point of the article is that China, just last year, they implemented 295,000 industrial robots into production of various industries. The United States, we introduced 34,200 robotics into service. And so this is part of that trend of robotics and automation that's occurring combined obviously with artificial intelligence. And so this is having an impact across the multiple industries across obviously the country, but Minnesota. Then the other headline is it's the same headline, just a different outlet. China now has more factory robots than the rest of the world combined. And so not only do we need to have that, even though they're far outpacing us, but what I'm concerned about is the amount of automation, the amount of data collection that's happening within China and the use of such products within the United States. And one, Madam Co-Chair, I had a conversation with you, and I mentioned I had a delegation of international artificial intelligence researchers and think tank personnel from across the world that were in my office about a month ago. And they were explaining how the amount of technology that China is putting into the world that is being adopted by countries across the world, it's harvesting information on citizens far more than even their own countries are. I mean, we those of us on this committee have a problem with that, but they're harvesting information from our citizens. And the one that the one woman from Sweden highlighted was the smart pillow, how it is a pillow that's emitting these brain waves that China's developed, that they have been able to configure it to emit certain types of frequency that can make a person more aggressive in the context of military, or somebody who might be suffering from depression it does something to counteract depression, or it can make somebody more, more happy or whatever. And the amount of information then that pillow is collecting from the person, from their brain waves in the United States, is directly related to data practices and how it's happening. Anyway, technology is out there. It's fast paced, and it's very alarming, and hence the reason for this commission, but needing to continue these conversations in a committee. Thank you.
Thank you, Senator Lucero, for freaking us all out. Senator Limmer.
Well, to add to the conversation, I was listening to a radio program early this morning about database centers and how the U.S. government and state governments quickly rushed to give the green light for database centers all across the country. The discussion was, what impact does it have on the rest of society? Just the construction and the use of those database centers. Database centers is estimated that in this country, once they're established by the year 2030, 4.5% to 5% of our total gross energy production will be used just in database centers. And within 5 more years, it magnifies to 10% of our total energy production. For cities that suffer brownouts, they're going to shift to blackouts. And those of us that don't worry about that problem, we may have to start to worry about that problem, because database centers are going to use up quite a bit of energy that we haven't even imagined. Again, the importance of having regular meetings on data privacy and its effect. I know that we had database appropriations for database centers in the last 1 and 2 years, and I don't think there was a whole lot of detailed discussion about those, but this legislature approved the financing of those. And so it's kind of a public-private regulated industry type of thing, but it will have its impact. And that's not going into the detail of data privacy, but we've created the energy source for all of this data accumulation. And so I think it's really important for us to continue. I'm going to say it again, have regular meetings. We really got to get ahead of this. And it is now quantum leaps ahead of us. It's going to be hard to keep up with it or catch up to it, but we can certainly give it our best shot.
Thank you, Senator Limmer. And before we get ready to adjourn here, I want to just ask one more question to the director and Mr. Harbady. And then you're obviously free to leave the table, but I know that you're working on some rules. And could you kind of give us a status update on that and what topics those rules are going to encompass, if you can, Director?
Yes. We are trying to update the whole chapter because they were written in 1979 and they were signed into law in 1981 and they haven't been updated since. So partly it's to reflect what has been pulled forward into the statute already to get rid of the duplicative language so there isn't any confusion, make some plain language updates. The Data Practices Act initially only applied to data on individuals, and so the rules only apply to data on individuals. So we wanted to broaden that because now we have defined data not on individuals. So we wanted to make sure the rules reflect that change that was made in statute. It is a huge project and we are just the four of us. So I was just at the Rules Committee seminar yesterday realizing just the enormity of this project. It's going to be fairly slow moving, but our goal is to do one big update to the chapter. And so that going forward, we won't have to do this kind of work. Where we are is we have an informal set of proposals just so people can have something to react to out. They're on our website. Folks can look at them, respond to them. We've had some initial rounds of comments and meetings with folks, but I anticipate we will keep those up, do some revising of the proposals throughout session and maybe next spring, either have a new set to react to. But this is all in the informal process still. We're not in the state register or at the Court of Administrative Hearings. We're just trying to get some feedback on where these rules should go and how to make them more helpful.
Thank you for that update. And I'm sure you will be as transparent as possible since that's what your office is sort of one of the things it represents. So yeah, I'm sure this commission will have a keen interest in that going forward and look forward to more conversations on those. And thank you for joining us today. It was very helpful. Thank you for being so kind to answer our questions and get a little more in depth than we have maybe in the past. So thank you so much. And I think you were planning on, I think I sent the email over the weekend that, oh, can you pivot? So thank you very much for being flexible.
Thank you.
Thank you.
Mhm. Any other member comments, questions? Before I go to Co-Chair Feist for kind of an update on what the next commission meetings are going to be about, what we're going to cover, I wanted to ask Ms. Olson if she knows the Data Commission in the budget, we've been given money in the past. Is there still money sitting there? And if so, how much and et cetera? Ms. Olson.
I would have to go back and check, but Nick Nero with our office is a research analyst that's been assigned to this. So is
Okay,
the
perfect.
researcher
Oh.
that's filling that role.
Oh, okay. Well, go ahead and Nick, introduce yourself. I failed to do that at the beginning, so please do.
Hi, Chair Scott, Chair Feist, Representative Elkins, Senators Warren and Limmer. My name is Nick Nero. I'm a research analyst with the LCC. And one of my duties is working for this commission. So if you have research questions, I'm happy to help.
So that's awesome. So that's how the money's being spent, is that?
Yes.
That's awesome. Thanks, Nick. Thanks, Nick. And I just wanted to have Ms. Olson introduce herself too.
Yeah, I'm Sally Olson and I'm a commission administrator with the LCC and I've staffed this commission since it started.
Yeah, and she doesn't have gray hair, so that's amazing. And I think what we would like to do, I think we need to just come up with dates for the next few months and just say this is when they're going to be. And we will meet with as many people as we can. And of course, we're going to hear from the public a good amount. Representative Elkins, before I go to.
Yeah, no, I
Coach
was just
Feist?
gonna say, I'm on 4 of these.
Oh.
DeMarco has access to my calendar, so he knows when I am available at all times in real time.
Okay, perfect. Co-Chair Feist, what's on tap?
Yay. We have 2 additional hearings that we've fully fleshed out. And then next one that I have some notes that we haven't actually talked about yet, but I can share some thoughts. So for hearing 2, we were thinking of focusing on emerging issues around privacy and technology. So some of the topics that we've collectively had conversations around include AI, which came up today, And these are also things that like Senator Lucero and Representative Elkins have mentioned around modern data privacy best practices, minimization, retention, maintenance, metadata, geolocation data, which Representative Elkins mentioned, the intersection of the Data Practices Act and healthcare privacy laws, consumer protection laws, and data sharing and fraud prevention. So our goal is to have a variety of stakeholders join us. We're looking for a good balance between institutional stakeholders and members of the general public. And one of the pieces of advice we had for stakeholders is that we encourage you, if you're all kind of in a group of people who have similar concerns, work together and have maybe one person testify to share those concerns. But the goal is to really hear about kind of what are the issues, the cutting edge issues that we're dealing with today. And then hearing 3 is thematically connected and kind of the next step. What are the challenges and what are the opportunities around the Data Practices Act? And, you know, I know one of the stakeholders I've had good conversations with is Hennepin County, and they invited me to do like a Data Practices Act request from beginning to end. And I was like, oh, that sounds like really huge. I don't know if I have the time or energy to commit to that. But I feel like this space would be a great space for government entities to come in and members of the public to come in and share both sides of like, how does this work in reality and where are the problems that we're facing? And to dream big, I think it's really hard in the context of a legislative session and a specific bill to like think really expansively about where we go from here. Oftentimes the bills we're bringing, there are like just, you know, fraught issues that are really specific to those bills or those stakeholders. And it would be so great to have a conversation that's just bigger, like structurally, like Representative Elkins was mentioning, you know, like, are there structural ways that we could move forward and really improve clarity and sustainability of the Data Practices Act? So I'm excited for that conversation. And then hearing 4, just throwing out some ideas and Representative Hudson's approach. I am obsessed with the body cam reports and the automatic license plate reader reports and like, what are we trying to do? I could ask my husband because he was involved with that back in the day. But you know, I just want to know, like, what are we trying to achieve? What are like, and you know, it'd be super interesting to hear, like, what are the challenges that, you know, local government entities face in preparing them and presenting them? What are they trying to get out of them? What do we want out of them? And the Fusion Center report that we created, it's had 2 reports. It'd be super interesting to have a conversation around that report. I look at it every year. I might be the only one, maybe the ACLU of Minnesota as well. And then just something I'm really interested in is reverse location warrants and the efficacy and the constitutionality of them. I think that would be just a really good big conversation to have rather than having it in the context of my specific bill. That was just like thrown out there for consideration for the 4th hearing. But yeah, that's kind of what we have on tap.
Thank you, Chair Feist, and thank you to our staff. And I think we have somebody to like direct our hey, Nick, can you look up XYZ to do a little bit of research for us? And so it's good to have you here, and I look forward to getting to know you better and everything. So with that, if there's nothing else, Senator Limmer or Lucero? Oh,
One thing.
Representative Elkins.
Just when I was moving my data privacy bill, you know, being able to have the hearing before this committee and get like a half an hour to have really good feedback was really invaluable to me in the process. And there are a number of legislators that I know of that are working on bills related to data privacy or artificial intelligence. And maybe in January, when some of these bills are better fleshed out, it might be a good idea to devote some time at a hearing, one of our hearings, to do the same thing with some of those bills as well.
You know, Representative Elkins, that sounds like a good argument for having a full committee to vet this stuff. And maybe you could be a co-chair of that committee. because you have some background in that, but we'll certainly take that under advisement and see what the common committee commission times,
It's just
what they produce. Yeah.
getting hard, getting time before the Judiciary Committee is really hard.
Oh, really? Well, I might be able to help you with that. Anyway, with that, members, there's nothing else. We are adjourned.
Using this weird. And my colleague for these office and really good products, like one PDF of like all the newspapers that we about crime and